相互认可和执行民商事案件判决的安排，简称安排。最高人民法
院特区政府在
2019年1月18日签订了安排。安排全面的机制，
减少
在两地因为同一争议重复
提出诉讼的要求，为当事人的利益提供更好的保障，以及提升香港作为区内法律和争议解决服务中心的竞争力。安排会透过本地法律在香港特区实行。立法会在2022年10月26日通过相关条例，所以今天也是香港法律内地民商事判决相互强制执行条例第645章及相关附属法律生效的大日子。香港司法机构已经在上周发出实务指示，
进一步订立落实方案。在内地方面，最高人民法院为安排的推行宣布司法解释。在这个重要的日子，我想邀请大家进行一个简单而隆重的仪式，一同见证安排及条例正式执行。接下来我会宣布安排实行，在我做出宣布之后，请大家用掌声响应，以表示对安排的支持和祝贺。我现在宣布，关于内地与香港特别行政区法院相互认可和执行民商事案件判决的安排，内地民商事判决相互强制执行条例第645章及内地民商事判决相互强制执行规则第645A 章，以及内地的司法解释法释2024 2号最高人民法院关于内地与香港特别行政区法院相互认可和执行民商事案件判决的安排，在今天2024年1月29日正式执行。在此，请各位来宾一同以掌声响应。感谢大家。在今天的研讨会，我们非常荣幸邀请到在法律领域具有卓越成就和丰富经验的香港及内地讲者，为他们分享我们的宝贵意见和专业。今天的研讨会设有问答环节，在研讨会进行期间，大家可以扫描屏幕上的2维码，进入网上平台提交问题。接下来事不宜迟，我们掌声有请香港特别行政区律政司司长林定国先生 SBS SCJP 为我们致开幕词。掌声有请林司长。
Vice President of the Supreme People's Court, Mr. Yang Wanwing, Chief Judge of the High Court of Hong Kong SAR, the Honourable Mr. Justice Poon, Judges and Judicial Officers of the Supreme People's Court and Hong Kong's judiciary, distinguished guests, ladies and gentlemen, good morning. It gives me great pleasure to welcome you all to today's seminar on the new mechanism for reciprocal recognition and enforcement of civil and commercial judgment between the Court of Mainland and the Hong Kong Special Administrative Region, co-organized by the Supreme People's Court and the Department of Justice of Hong Kong SAR. I would like to begin by expressing our utmost gratitude to the Supreme People's Court for its unwavering support in making today's seminar possible, as evidenced by the presence of the very strong delegation led by Vice President Yang. I would also like to thank the Hong Kong judiciary for participating in the seminar. Today marks an important milestone for both the mainland and Hong Kong, because the arrangement on reciprocal recognition and enforcement of judgment in civil and commercial matters by the Court of the Mainland and of Hong Kong Special Administrative Region conclude on the 18th of January 2019, formally take effect in both places. After about 4 years' hard work upon the conclusion of the arrangement, all legal steps to implement it in the mainland and Hong Kong have been completed. From today onwards, in Hong Kong, mainland judgment in specific types of civil and commercial cases may be recognized and enforced through a new statutory regime under the Mainland Judgment in Civil and Commercial Matters Reciprocal Enforcement Ordinance, Chapter 645 of the Laws of Hong Kong. At the same time, in the mainland, Hong Kong judgment of the same types may be recognized and enforced in accordance with judicial interpretation promulgated by the Supreme People's Court on the 25th of January 2024, which comes into effect today. As I said at last Monday's ceremonial opening of the legal year, the common law system in Hong Kong is a unique advantage that must be utilized to promote the development interests of China and to maintain the prosperity of Hong Kong, which are indeed fundamental purposes of the one country, two systems principle. And while it's essential to maintain a clear demarcation between the legal system of the mainland and that of Hong Kong, it's necessary to construct linkages between the two systems so that the unique advantages offered by Hong Kong's common law system may be fully utilized to serve the national interests of China as a whole. This is achieved by, among other things, the conclusion of different types of mutual legal assistance arrangement between the mainland and Hong Kong, pursuant to Article 95 of the Basic Law. The arrangement is indeed an excellent example, demonstrating how such a mutual legal assistance arrangement enable Hong Kong to better utilize the unique advantage offered by Hong Kong's common law system. The arrangement is both unique and advantageous. Let me first explain why the arrangement is unique. First and foremost, Hong Kong is the only jurisdiction that has entered into such an arrangement with the mainland on reciprocal recognition and enforcement of civil and commercial judgment. There's no similar arrangement between China and other jurisdictions in the world. For other jurisdictions, in particular common law jurisdiction, which do not have a similar arrangement with the mainland, a judgment creditor seeking to recognize and enforce a mainland judgment will need to rely on common law principles, under which one has to commence a fresh action before the court. It's well known that these common law principles are difficult to apply in practice. For example, it can be very tricky to determine whether mainland judgment is final and conclusive, which is an essential element needs to be proved under the common law principles. Another reason why the arrangement is unique is the wide scope of judgment covered by the arrangement. The arrangement covers a wide range of judgment on contractual and tortious dispute, and most importantly, certain types of dispute over intellectual property rights. In comparison, even in the Hague Convention of the 2nd of July 2019 on the recognition and enforcement of foreign judgment in civil and commercial matters, which came into effect on the 1st of September 2023 and applied to almost 30 European countries, intellectual property judgment are completely excluded. The arrangement is advantageous because it's beneficial to the business community and other people involved in civil and commercial dispute involving cross-border elements. If and when there's a need to recognize and enforce a mainland judgment falling within the scope of the arrangement in Hong Kong, people can do so in a much more simple and cost-efficient manner. The arrangement will make the option of choosing Hong Kong, having a common law system which the international business community is familiar with and have confidence in, as the jurisdiction to resolve any contractual dispute more attractive, knowing that a Hong Kong judgment may be recognized and enforced in the mainland where the assets of the other contracting party are located. This will be conducive to enhance Hong Kong's status as an international legal service and dispute resolution services center. It may also make investors and business people from other countries more ready to explore investment and business opportunities in the mainland. I would like to take this opportunity to highlight two key characteristics of the arrangement implemented by the ordinance in Hong Kong, which are indeed interrelated. First, the fundamental principles behind the mechanism under the arrangement are consistent with the prevailing international practice as reflected by, for example, the above-mentioned 2019 Hague Judgment Convention. Indeed, one could see that the provisions of the arrangement are very similar to those of the Hague Convention. The prevailing international practice aims at promoting judicial cooperation between different jurisdictions, avoiding multiplicity of legal proceedings in different jurisdictions, and providing a convenient way to enforce a foreign judgment, provided that the foreign judgment was obtained in a fair and proper manner. And this takes me to the second key characteristic. The second important characteristic of the arrangement is that it strikes a proper balance between facilitating recognition and enforcement of judgment obtained in other jurisdictions from the perspective of the judgment creditor on the one hand, and ensuring that only judgment obtained properly and fairly will be recognized and enforced from the perspective of the judgment debtor on the other hand. If a party wishes to enforce a mainland judgment in Hong Kong, the ordinance provides a relatively straightforward registration system, whereby he can make a registration application to the court. In essence, all that he needs to do is to provide an authentic copy of the mainland judgment and a certificate from the mainland court that the judgment is one in civil and commercial matter which is effective in the mainland, and make an affirmation providing some essential information. If the court approves the registration application, the mainland judgment will have the same effect as if it were a judgment originally given by the Court of First Instance of Hong Kong on the day of registration. In practice, this means that the mainland judgment may be used as a legal basis to take further enforcement procedure against the judgment debtor or his assets in Hong Kong, such as bankruptcy or winding up proceedings, charging order against real properties. The new mechanism reduces the need for relitigation of the same dispute and the need to rely on the complicated common law principles to enforce mainland judgment. It also reduces the cost and time usually associated with the legal proceedings and recognition and enforcement of such judgments. On the other hand, the ordinance provides sufficient safeguard to protect the legitimate interests of the judgment debtors. The ordinance contains a setting-aside procedure whereby the applicant must notify the judgment debtor of the registration order, and that the judgment debtor has a right to apply to the court to set aside the registration. The ordinance sets out specific grounds on which a party may rely to set aside registration, which include, for example, when the mainland judgment was obtained by fraud, the defendant in the original mainland proceedings was not summoned to appear or was not given a reasonable opportunity to defend the proceedings, or on the ground of lack of jurisdiction of the original proceedings. While the Hong Kong court will not reconsider the substantive merit of the mainland judgment, these setting-aside procedure serve to ensure that a mainland judgment will only be recognized and enforced in Hong Kong if it was obtained as a result of due process and in compliance with fundamental principles of justice and fairness. It's noteworthy that further steps to enforce a registered mainland judgment may only be taken after expiry of the period given to the judgment debtor to apply for a setting aside. There are other provisions in the ordinance to prevent concurrent or multiplicity of proceedings in both the mainland and Hong Kong, and the risk of inconsistent judgments. For example, if a party obtains a judgment in the mainland and applies to register in Hong Kong, the ordinance provides that any pending Hong Kong proceedings in respect of the same cause of action between the same parties must be stayed. Further, if the mainland judgment has already been registered in Hong Kong, a party may not bring the same cause of action in the Hong Kong court again. I hope by now I have said enough to whet your appetite. Today, we are very honored to have eminent judges and legal practitioners from both the mainland and Hong Kong who will speak and elaborate on various issues that I have outlined. To ensure that the ordinance can serve its intended purpose, it is of crucial importance to ensure that both lawyers and potential users fully understand how the new statutory mechanism will actually operate. Apart from organizing today's seminar, the Department of Justice has set up a designated web page on its website including not only the links to the e-versions of the ordinance and the subsidiary legislation, but also a pamphlet and frequently asked questions which explain the legal provisions in a user-friendly manner that layperson could easily understand. I'm very delighted that over 200 persons attend today's seminar in person. They include fellow legal practitioners, Consul Generals of foreign countries in Hong Kong, legislative councillor, friends from the business and banking sectors, etc. There are also friends attending this seminar online in Hong Kong and from the mainland. I would like to thank all of you for your participation in today's seminar. And I must, of course, thank all the distinguished speakers for your enthusiastic and valuable contribution to the seminar, in particular those coming from the mainland. Lastly, I wish you all a very fruitful and enjoyable seminar. Thank you very much.
Thank you very much, Mr. Lam. Please be seated. 谢谢林司长，可以先移步到台下就坐。接下来，我们掌声有请最高人民法院杨万明副院长来到台上为我们致开幕词。掌声有请。
尊敬的林定国司长、潘兆初首席法官、各位嘉宾、女士们、先生们，大家上午好。三阳不死，四序初开，很高兴在龙年的新春即将到来之际与各位相聚在香港，庆贺内地与香港司法协助领域又一座里程碑意义的重要的时刻。今天能够见到各位老朋友，感到非常亲切，还接受了不少香港司法法律界的新朋友，感到非常高兴。2019年的1月，最高人民法院与香港特别行政区律政司在北京共同签署关于内地与香港特别行政区法院相互认可和执行民商事判决安排。去年底，香港完成了本地立法。刚刚司议小姐宣布了内地民商事判决相互强制执行条例及内地民商事判决相互执行规则，宣布这样一个好消息。林定国司长在刚才的开幕致辞当中，对这个新的规定做了精准精彩的解读。近日最高人民法院也发布了相关的司法解释，这标志着内地与香港特别行政区民商事判决互认新机制已经正式落地施行。受首席大法官张军院长的委托，我谨代表最高人民法院向为新机制的建立和实施作出卓越贡献的内地与香港各位司法法律界同仁表示热烈的祝贺，向出席此次研讨会与我们共襄盛举、擘画未来的各位嘉宾表示诚挚的谢意。新时代新征程，我们正以中国式现代化全面推进强国建设、民族复兴这样一个伟业，推进强国建设、民族复兴，离不开香港长期繁荣稳定。中央坚持全面、准确、坚定不移贯彻一国两制方针长期不变，支持香港融入国家发展大局，推动香港实现更好的发展。在特别行政区政府的带领下，香港顺利完成区议会换届选举，走出疫情影响，迎来了整体的复苏，逐步巩固了由乱到治的大势，迈向了由治及兴的新局面。一国两制的强大生命力和优越性 不断的显现。新时代新征程，内地与香港司法法律人以高度的责任感、使命感，坚守一国之本，善用两制之力，不断优化和完善中国特色区级司法协助体系，以司法的现代化更好地支撑和服务中国式现代化。在这继往开来的重要时刻，我们也更加期待内地与香港的司法协作有新气象、新作为、新成效。借这个机会，我谈几点期待：一，要牢记初心使命，护航一国两制行稳致远。非凡的时代催生伟大的理念，一国两制从伟大构想到成功实践，为新时代保持香港、澳门长期繁荣稳定，实现中华民族伟大复兴明确了前进的方向。内地与香港已签署了9项司法协助的安排，基本实现民商事领域司法协助的全覆盖。在司法领域不断的丰富和发展一国两制的制度体系。内地与香港特别行政区民商事判决互认新机制是新时代践行一国两制的新的乐章，我们参考但不囿于国际司法协助互认执行的范围，也将知识产权等国际公约明确排除的判决类型也涵盖在我们的这个新机制之中，实现了一国之内最大范围的互认执行。我们期待两地司法法律人以新机制为新起点，继续拾阶而上，努力前行，不断地推动司法法律规则衔接的新发展，不断地深化一国之内更紧密、更包容、更互信的司法联系，充分彰显一国两制的制度优势，也为不同法系的司法制度的融合发展提供更多的香港经验、中国经验。二是弘扬法治精神，着力提升治理水平。法治是国家治国理政的基本方式，也是香港保持繁荣稳定的基石。新机制是内地与香港司法法律规则的一次全面的对接，也是内地与香港协力推进社会治理、国家治理的一次全面的合作。跨境民商事案件是司法法律规则的一个鲜活的载体，反映了经济社会发展的状况，蕴含着广泛的社情民意。两地法院要在综合考虑跨境当事人的诉求、两地法律规则的差异、各自执行机制的特点等等基础上，公平公正、创造性地做出便利跨境认可执行的判决和判项，促进判决跨域流通和执行。要加强跨境民商事案件的梳理总结，加强案例规则的供给，合力打造更优的法治化营商环境，切实为一国两制事业发展和实践注入更多鲜活的法治元素。三是横念发展要义，推动香港融入国家发展大局。香港背靠祖国，连通世界，是不同法系跨境法律规则衔接的重要联系人，也是我们国家加强涉外法治建设、携手参与国际合作和全球治理的一个重要窗口和重要力量。新机制建立了内地与香港更为成熟便捷的互认机制，将极大地增加域外当事人选择香港法院来解决涉内地资产案件的需求，激发内地企业借力香港超级联系人走出去的期许，为香港建设亚太区国际法律与争议解决 中心增加新的发展动能。我们希望我们共同努力，将这个新机制的好故事讲得更精彩、更实在、更加深入人心，支持香港把握国家新一轮更高水平开放的新机遇，全面的对接“十四五”规划、粤港澳大湾区建设和高质量共建“一带一路”这些重大国家战略，同内地实现优势互补，共同发展。四是要常思民众所盼，切实做好跨域溯源治理。新机制是司法协助体系中与民众联系最紧密、关注度最高的这个安排之一。结合此前已经生效的婚姻家事安排，可以说我们新机制下，内地与香港90%以上的民商事案件能够互认与执行，为当事人免除了重复诉讼的这样的诉累。法律的生命力在于实施，跨域民商事案件互认与执行它这里边有关乎到这个经贸往来这样的大事，也有普通民众，特别是香港居民在大湾区工作生活当中的一些小事。所以我们要以如我在述的精神，将跨域民商事纠纷的大小案件都审理好，要沟通好、执行好，探索建立新机制的一些配套服务保障平台，为当事人申请互认和执行提供更多的便利，以实实在在的公正和效率，这是我们人民法院的工作主题，真正让两地民众在新机制中感受到获得感、满意感。各位同仁、各位嘉宾，一元复始，万象更新。正值农历新年即将到来的时候新机制的运行开启了内地、香港司法协作的新航向。我们相信，新时代新征程，两地司法法律界的同仁一定能够继续沿着一国两制方针和香港基本法的轨道，守正创新，共促发展，共同书写交流合作的新篇章，为香港的繁荣稳定，为实现中华民族伟大复兴，不断地做出我们更大的贡献。最后，预祝我们的研讨会今天的会议这个圆满成功，祝各位新春快乐，龙年大吉！谢谢大家。
谢谢杨副院长，请留步，请留步，可以先移步到台中间的位置，我们会进行一个合影的环节。安排的顺利实行，有赖最高人民法院与香港律政司以及司法机构的支持。接下来，我们掌声有请香港特别行政区律政司司长林定国先生来到台上，有请林司长。接下来，我们掌声有请高等法院首席法官潘兆初法官，有请。接下来，我们邀请高等法院司法常务官邝卓宏先生，有请。接下来，邀请律政司法律政策专员梅基发先生，有请。然后邀请最高人民法院研究室主任周家海先生，有请。然后邀请最高人民法院研究室副主任司艳丽女士，有请。以及最高人民法院民事庭郭在宇法官，有请。欢迎台上所有的嘉宾们。 请台上所有的嘉宾们先看一下我们大会摄影师，先来一个合影。我们请台上所有嘉宾一起比个赞，来支持我们今天的研讨会，好吗？我们一起比赞来支持我们今天的研讨会。我们继续留步，继续留步，给我们后面的媒体朋友也来一个合影。好，我们继续比赞，再给我们的媒体朋友再来一张合影。好，我们再次掌声，谢谢我们台上所有的嘉宾们，可以先移步到台下就坐。感谢台上所有的嘉宾们今天的出席，支持我们今天的研讨会。那由于杨副院长及林司长另有公务，他们会先行离开，再次感谢两位。谢谢。接下来我们会进入主旨发言环节。首先，我们会邀请高等法院首席法官潘兆初法官为我们发表。潘法官自2019年12月18日起出任高等法院首席法官，他也出任司法机构内部委员会及工作小组的主席或成员，拥有丰富的法律经验。接下来，我们掌声有请潘法官。
Deputy Director C, distinguished guests, ladies and gentlemen, good morning. It is a great pleasure to deliver this keynote speech at today's seminar to mark the implementation of the arrangement on reciprocal recognition and enforcement of judgments in civil and commercial matters by the courts of the mainland and the Hong Kong Special Administrative Region. I extend my warmest welcome to all participants, both attending in person and online, to this important event. Signed by the Supreme People's Court and the government of the HKSAR on 18th January 2019, the REJ arrangement is the latest and perhaps the most significant step taken so far to foster the legal and judicial cooperation under the mutual legal assistance framework between the mainland and Hong Kong. I will highlight some of the significant features of the REJ arrangement in a moment. As an introduction, I would like to say a few words about the MLA framework and outline very briefly the development in the area of mutual recognition and enforcement of judgments. The MLA framework is more than a mechanism to address the practical needs arising from the closer economic and social ties between the mainland and Hong Kong since 1997. It is a manifestation of the one country, two systems principle as enshrined in the Basic Law. Under that principle, Hong Kong remains the only common law jurisdiction in China where a civil law system operates. Because of the differences between the two systems, challenges, including those in the legal field, inevitably arise when cross-border economic and social interactions increase. And when Hong Kong, in pursuing the central government's policy initiatives, takes further steps to integrate into the overall development of the country. There is accordingly a pressing need to meet those challenges lest they become obstacles, and more importantly, to enable Hong Kong to best serve the country's interests by making full use of its strengths and advantages. That is the primary objective of the MLA framework, in providing a solid and sustainable framework for mutual legal assistance and arrangements to be made to respond to the changing legal and economic landscapes, thus giving substance to the one country, two systems principle in this crucial area. It must also be stressed that MLA framework is underpinned by the rule of law. Its constitutional basis is provided for in the Basic Law. Under Article 95 of the Basic Law, the HKSAR may, through consultations and in accordance with law, maintain juridical relations with the judicial organs of other parts of the country, and they may render assistance to each other. When it is necessary, legislative measures will be adopted by both the mainland and Hong Kong for implementing an arrangement made under the MLA framework. Typically, the SPC promulgates judicial interpretation and Hong Kong passes local laws to give effect to the arrangement. Under the MLA framework, the mainland and Hong Kong have since 1997 entered into 9 arrangements on 4 broad areas relating to mutual legal assistance in civil and commercial matters. They cover, firstly, procedural assistance, such as service of judicial documents and taking of evidence. Secondly, arbitration-related assistance, including court-ordered interim measure in aid of arbitration and mutual enforcement of arbitral awards. Thirdly, mutual recognition of and assistance to bankruptcy, insolvency proceedings. And fourthly, mutual recognition and enforcement of judgments, including judgments in matrimonial and family cases. In respect of mutual recognition and enforcement of civil and commercial judgments, the first arrangement is the arrangement on reciprocal recognition and enforcement of judgment in civil and commercial matters by the courts of the mainland and of the HKSAR, pursuant to choice of court agreements between the parties concerned. That agreement came into force on the 1st of August 2008. It was implemented in Hong Kong by the mainland judgment's Reciprocal Enforcement Ordinance Cap 597, and in the mainland by the judicial interpretation promulgated by the SPC. The second is, of course, the REJ arrangement. It is implemented today in Hong Kong by the mainland judgments in civil and commercial matters, Reciprocal Enforcement Ordinance Cap 645, the mainland judgments in civil and commercial matters, Reciprocal Enforcement Rules, and Practice Direction 38, and in the mainland, the corresponding judicial interpretation by the SPC. Before Cap 597, mainland judgments could only be enforced in Hong Kong under the common law by way of an action on debt. There was no legal basis for enforcement of Hong Kong judgments in the mainland. The 2008 arrangement introduced a significant change to that. Monetary judgments given by a designated court of either the mainland and Hong Kong relating to business agreements in which the parties have agreed in writing to designate a People's Court of the mainland or court of the HKSAR as a forum to have sole jurisdiction to resolve disputes can now be enforced. The REJ arrangement takes another giant step. It applies to matters considered to be of a civil and commercial nature under both Hong Kong and mainland law. Non-judicial proceedings and judicial proceedings relating to administrative or regulatory matters are excluded. It covers both monetary and non-monetary relief. It also sets out the jurisdictional grounds for the purpose of recognition and enforcement, as well as grounds for refusal of recognition and enforcement. The practice and procedure under Cap 645 and the rules are broadly similar to those under the Hague Convention on the recognition and enforcement of foreign judgments in civil or commercial matters, thus reflecting the prevailing international practice for mutual recognition and enforcement of judgments. In particular, I would like to draw your attention to the following points. First, the scope under the REJ arrangement has been widened considerably. Unlike Cap 597, which covers only monetary judgments, the REJ arrangement covers both monetary and non-monetary judgments. Further, it also extends to specified intellectual property rights. That is significant because it will greatly enhance Hong Kong's position as a center for intellectual property development, as IP rights can now be enforced by the courts of Hong Kong, both locally and in the mainland. Second is a simpler enforcement mechanism. Unlike Cap 597, it is not a prerequisite to recognition and enforcement of civil and commercial judgments that the parties have made a choice of court agreement. It would avoid interesting but difficult questions or disputes over whether mainland judgment to be enforced is a final judgment. It should make recognition and enforcement of judgments easier. Third, and I must stress, it does not mean that judgments will be automatically recognized or enforced mutually. For there are procedural steps governing the application for recognition and enforcement, and also refusal of recognition and enforcement of a judgment, which must be strictly and fully followed. Those steps are set out in the rules to Cap 645 and Practice Direction 38. Fourth, with the clear legal basis for enforcement of Hong Kong judgment in the mainland, through the judicial interpretation issued by the SPC today, there's no longer the need to relitigate the same dispute in the mainland, thereby saving time, cost, and resources, and reducing uncertainty and stress associated with relitigation. Fifth, with the REJ arrangement working in tandem with the 2008 arrangement, the mainland judgments in matrimonial and family cases, Reciprocal Recognition and Enforcement Ordinance, Cap 639, which came into effect in February last year, 2 years ago, sorry, and the record of meeting on mutual recognition of assistance to bankruptcy insolvency proceedings between the court of the mainland and HKSAR, signed in May 2021. We now in Hong Kong have a comprehensive regime whereby most of the general civil or commercial judgments may now be mutually recognized and enforced. This is indeed a unique advantage, adding strength to Hong Kong as an international financial center and dispute resolution hub. Sixth, across the border, the significance of the wider coverage of mutual recognition and enforcement judgments will most probably be felt by mainland courts within the Greater Bay Area, which cover over the years a large number of cross-border civil and commercial cases that have a wide spectrum, ranging from contract, tort, company disputes, to IP rights and MOT cases. This may well pave the way for closer judicial cooperation between those mainland courts and Hong Kong courts in the future. The benefits that the REJ arrangement generates are enormous. As just alluded to, it will avoid the need for relitigation of the same disputes in both places, save litigants substantial time and cost, and reduce the stress for them. On a macro level, it will enhance public confidence in the legal system, facilitate economic integration and development, and optimize business environment underpinned by the rule of law for both the mainland and Hong Kong. It will surely increase the attractiveness of Hong Kong as a regional dispute resolution hub. To conclude, as the only common law jurisdiction that enjoys such a comprehensive mutual legal assistance scheme for arbitration and civil and commercial matters with the mainland under the MLA framework, Hong Kong will continue to strive as an international financial center and dispute resolution hub in the region. This really underscores the unique strengths and advantages that we have under the one country, two systems principle. Finally, it remains for me to thank the Supreme People's Court and the Department of Justice for co-organizing this seminar, and all the distinguished speakers for their contribution. Thank you very much.
Thank you very much. 谢谢潘法官，可以先移步到台下就座。接下来，我们掌声有请最高人民法院研究室副主任司艳丽主任、司主任熟悉两地司法协助工作，用心推动和完善民商事司法协助的体系。我们掌声有请司主任。
尊敬的潘兆初首席法官，各位嘉宾、女士们、先生们，大家上午好！很高兴，也很激动，参加今天的研讨会。为什么说很激动呢？因为在2019年这项安排磋商的过程中，我是这项安排磋商团队的代表，应该说呢是全程参与了这项安排的磋商。双方团队呢是历经2年的时间， 从一个字到一个条文，再到今天的安排，可以说呢是双方相互尊重，求同存异，从怎么更有利于两地民众的利益出发，最终呢达成了最大公约数，达成了今天的这个共识，可以说真的是来之不易，所以也是非常的激动。那今天呢能够有幸又来见证这项安排落地实施，就像当年种下的树，今天终于结下了丰硕的果实，非常的开心。我想在此首先要向为这个安排能够落地实施而付出卓越努力的香港律政司、香港司法机构以及香港法律界的各位同仁表示崇高的敬意，也为在座的各位嘉宾关注、关心这项安排表示由衷的谢意。下面呢，我就将结合这项安排与各位共同回顾香港回归以来两地司法法律规则衔接的实践